Okay, I'd like to thank everybody for joining us today. And welcome to the Teacher Roundup. I don't know how many we've had now, probably 6 or 7 of these. So we think we have a really good program today. We've got 2 people with us today to cover alternatives to guardianship, and we're really happy to have you guys along. When we get done with your presentation, Brian and Carrie, then we've got a few things that we'd like to cover as well, as far as upcoming events and things that we'll have on our website. So when you're done, we'll chat about those things. To get started, I'd like to introduce Brian Polstra and Carrie Gephardt. I really want to thank you guys for joining us, and they're going to go over alternatives to guardianship. Brian is with Advocacy Services Representative with Disability Rights South Dakota, and Carrie Gephardt is with Children's Support. She is a Children's Support Manager with the Division of Developmental Disabilities, and they've got some experience with this, but it's one of these things that we have come up often. It's the guardianship issue, so it's really nice to have you guys, and I'm going to turn it over to you. So thanks for being with us.
Okay, I get to go first. That I think it would dovetail better. Is that okay, Carrie?
Absolutely.
Okay. Let me see if I can get this screen sharing thing to work here a minute. Okay, so what are you seeing? Can someone just give me some feedback on what you're seeing here for screens? Are you seeing?
We're seeing the correct thing, Brian.
The 2 slides.
Just the 1 slide.
Just the 1 slide. Okay.
Yep.
Like Dan said, my name is Brian Polstra. I am a program lead and an advocate with Disability Rights South Dakota. I work out of our peer office. We have offices in Sioux Falls and Rapid City as well, allowing us to cover the entire state, provide services to the entire state. I'm grateful for you guys having me here. This is, I will be honest, this is the first one of these that I have been a presenter as opposed to simply a participant. So if I stumble over my words a little bit today, I ask that you bear with me. What I'm going to be covering today is I'm just going to give information on guardianship and the alternatives to guardianship, because there are alternatives to guardianship. We get asked this quite a bit. And then I'm going to turn it over to Carrie for more into the decision-making processes, I believe. So, so I will try and keep it brief. If I start to ramble, somebody say something to me. So what we're talking about today, guardianship, its alternatives, information about guardianship that you want, but are afraid to ask for. See if I can make this work. So what happens when a child turns 18 years old? Upon turning age 18, you know, all children, this includes children with disabilities, they are legally considered an adult. For children with disabilities, this means that there is going to be a transfer of rights from the parent to the child. So what does the transfer of rights mean? It means that all parental rights and responsibilities that are part of the IEP process transfer from the parent to the child. This includes the right to having notice, right to procedural safeguards under IDEA, and also advocating for their educational needs. The school districts are, through the IEP team, they are to notify both the child / individual and the parents of the transfer of rights that is going to occur. In the state of South Dakota, this is required that this occurs no later than 1 year prior to reaching the age of majority, or age 18. So this means it should occur on or before the individual's 17th birthday. So, you know, it doesn't mean you have to wait until their 17th birthday, but it has to be done by their 17th birthday. This notice of the transfer of rights has has to occur. So in South Dakota, what options are available in South Dakota? South Dakota has a few options. They have guardianship and conservatorship. And then South Dakota also has what is known as supported decision-making and power of attorney. So as we go on here, I'm going to just kind of explain these, expand on them a little bit. So when we talk about guardianship and conservatorship, what is guardianship? Guardianship is a legal relationship between the guardian and the person that they are guardian of. It is established by the court. There are various types of guardianship. There's full guardianship, which may encompass all of the personal affairs of the individual. As we'll see later on, you know, where they live, who they're around, what they have access to. There's limited guardianship, where the guardian may have authority only over selected areas of the individual's affairs. Guardianship can be temporary, and what that means is the guardianship is established for a limited time frame. So it may be, you know, 90 days, it may be more. And joint guardianship, which is more than one person is appointed to be the guardian. So then conservatorship is also a legal relationship that is established by the courts. And while we're on the subject of legal relationships, I am going to say here real quick, I forgot to add, I am not one of our attorneys. Like I said, I am one of our advocates and a program lead. So when it comes to the legal advice, that's not my area. So back to conservatorship. Conservatorship is limited to the management of property and financial affairs. It can be like guardianship. Conservatorship can be full, limited, temporary, or joint. So there are, when one becomes a guardian or a conservator, there are duties that are required of the guardian or the conservator. They must maintain contact with the protected person to become familiar with their needs and limitations, and only exercise their decision-making authority to the extent required by those limitations. So they must respect the fact that their relationship with the protected person is confidential, and they should encourage the person's participation in decision-making to the extent possible. So, you know, they're not trying to have it as an authoritarian relationship where the guardian makes all of the decisions. You want to involve the person who you're who they are the guardian of. You want their input into these decision-making processes. And then they are required to provide information to the court. This includes information pertaining to the protected person's finances and personal inventory, as well as an annual personal status report, you know, made to the court. So you know, what are alternatives to guardianship? And there are some. One is power of attorney. Power of attorney, or I may start referring to it just as POA. Power of attorney can be considered an option if the person has the ability to understand and sign contracts, but needs assistance in certain areas of decision making, and they may need someone to be able to sign documents, you know, on their behalf for those purposes. So they may understand contracts and be able to sign contracts or enter into contracts, but they need assistance with some decision making and may need someone to sign these documents on their behalf. The most common powers of attorney are usually for financial affairs and for healthcare matters. I'm sure a lot of folks have heard of it referred to power of attorney for individuals who are receiving health care. Now, with a power of attorney, the individual must be at least 18 years of age to enter into a power of attorney agreement. Now, at least 18 years of age, a power of attorney agreement anytime after 18, they can enter into that agreement. They don't, you know, you can be 20, or it doesn't have to happen by age 18. And then it can't happen. A power of attorney can happen anytime. It just must happen after the individual must be at least 18 years of age to enter into a power of attorney agreement. There are different types of power of attorney as well. There is durable and non-durable. I've kind of outlined some of the specifics for each here. Durable power of attorney is what it says. It remains valid and it remains in effect even if the individual becomes incapacitated and unable to make decisions for themselves. So if you have a durable power of attorney and the individual becomes unable to make their own decisions for themselves, that power of attorney stays in effect, and the individual who has been granted power of attorney still has the power of attorney. It sets in writing a person's authority to make decisions on an individual's behalf, even if they are incapacitated. It can take effect immediately, or it can be set up to take effect upon the individual becoming incapacitated. So it can be immediate. I'm going to kind of pick on Carrie a little bit because I know her. We could set it up where if I was granting power of attorney to Carrie, I could set it up where Carrie would have power of attorney for me now or starting tomorrow, or only if she would have power of attorney for me only if I become incapacitated. So that's what that means. And the thing with the durable power of attorney, it is recommended that it be drafted by an attorney. Non-durable power of attorney, on the other hand, authorizes a person or persons to act on behalf of an individual. It can be granted verbally. So, but it is better if it is set out in writing, if there is written proof that it did occur. So again, referring back to a power of attorney agreement between myself and Carrie, a non-durable power of attorney is I could verbally give Carrie permission to make decisions for me. But it's better if I have it in writing. Non-durable, unlike durable power of attorney, non-durable power of attorney ends if the individual who granted the power of attorney becomes incapacitated. So if I give Carrie power of attorney, but it's non-durable, if I become incapacitated or unable to make my own decisions, Carrie's power of attorney is then ended. So, and power of attorney can be revoked. And they can be revoked at any time. Both durable and non-durable power of attorney can be revoked. Like I said, durable power of attorney must be revoked before the individual who granted the power of attorney becomes incapacitated or unable to make their decisions on their own. So if the individual becomes incapacitated and has not revoked a durable power of attorney, that power of attorney stays in effect. Non-durable power of attorney can be revoked at any time by the individual who granted it, and is automatically, like I said earlier, it's automatically revoked if the individual becomes incapacitated.
Brian, I'll just add right here, since you're picking on me. So the main difference between guardianship and power of attorney is guardianship, it has to be granted by a judge. Only a judge can take away an individual's rights. It has to go through the court system. The benefit of having a power of attorney is that person, so I would have to give Brian permission to be my power of attorney. I am giving Brian permission to make decisions on my behalf. If I have a durable power of attorney, I am saying Brian's my person. If I were to become incapacitated, Brian's my person to help me make those decisions. But at any time, if I say, you know what, Brian, I don't want you to help me make decisions. I want Cindy to help me make decisions now. I can have that revoked at any time. And so the difference is that can be done outside of a court system. Guardianship has to go. So say somebody doesn't like their guardian anymore, which, as you know, happens, then that individual actually has to go through the court system, and a judge has to change guardianship to a different individual. Okay.
Carrie and Brian, this is Cindy. I have 2 questions about this.
Okay.
For one thing, so my son signed a paper at the clinic saying I can talk to the doctor and come in with him to appointments and stuff. He wanted that. Is that a power of attorney? We signed something or not? Or is that just a health?
That would, my guess, and like I said, I'm not an attorney, so I'm just guessing that would probably be more like a release of information.
Okay, all right. Then the other question, Carrie, that example that you used, can you use something like that for bullet number 3? I'm confused on that one.
So non-durable power of attorney is less likely used in South Dakota. Durable power of attorney is most likely used because it is a written legal document. So a power of attorney is a legal document, whereas the non-durable power of attorney is more like a verbal agreement. So what you just described with your son most likely was a release of information, but because they want you to sign something, but he certainly could invite you to be a part of a phone conversation. Say he calls the telephone company because he wants to talk about his phone bill, and he verbally gives you permission to help him make those decisions while you're on the call. Is that a better example?
Yes, but what I didn't understand is what individual, so non-durable can be revoked by an individual who granted it and is automatically revoked if what individual becomes incapacitated? The individual who granted it?
The person needing supported decision making.
Okay, alrighty. I don't know that, okay. Sorry about that, but I just needed that straight in my head.
And actually, if when you drop down to the next bullet here, both durable and non-durable power of attorney are terminated if either the individual giving or the person given the power of attorney pass away. So if to bullet point 3, if the person who gave the power of attorney becomes incapacitated, the non-durable power of attorney ends. So, but if you see, if the person, if Carrie granted me power of attorney, and it was durable or non-durable, and I pass away being her power of attorney, obviously my power of attorney over Carrie ends. It's really kind of tough for me to make decisions if I'm no longer breathing. So,
yeah, and I think it's important too to note that guardianship doesn't have to be established at 18 or before the individual turns 18. Maybe we're not quite sure with growth and maturity that they will need a long-term guardian. So a release of information can be signed at IEP meetings so that the parent can still be involved. A power of attorney could be established so that that family member can still help them make decisions with their supports and services. Guardianship does not have to be established at age 18. It can be established after age 18 as well.
I have a question though. So if the student turns though 18, can't they suddenly say, I no longer want my parent in my IEP though? Isn't that correct?
Yes.
Okay.
Yep. So, but just because you don't want your parent in an IEP meeting isn't a reason to obtain guardianship over somebody's all decision-making abilities.
Right, right. But parent, okay. But
Yeah.
but still that's that whole thing that, parents sometimes think that, they're automatically, because they're still their parent, that they can automatically be in an IEP, but that's not the case.
Yeah, I have adult children without disabilities that still want their mom to be a part of a lot of their decision making. So I think that it's all about interpersonal relationships and really figuring out the why behind why they don't want their parent involved. Because ultimately, and sorry, Brian, we kind of hijacked your presentation a little bit. We'll get back to the supported decision making, but it ultimately is super important to really discover what the individual wants, because a lot of times the individual and the family member disagree. And it's ultimately, with or without guardianship, it's ultimately the person making decisions for themselves with support. Because if they don't want to do something like go to school, they're not going to go to school, whether they have a guardian or not. And you probably all have lots of stories to tell about some of those experiences. So, all right, let's talk about supported decision making. Go ahead, Brian.
I was just going to get my popcorn. You were doing good. So supported decision making is the process of assisting a person, like Carrie was just talking about, assisting a person with a disability to make their own decisions. It allows them to develop and pursue their own goals, to make their choices about their life and exercise some control over things that are important to them. You know, it's kind of, without getting up on a soapbox, it kind of gives the individual the chance to fail or the chance to succeed. You know, I mean, it gives them that chance. So it can be used in both educational context, but it can also be used for adults with disabilities as well. This is kind of, I know today is kind of geared at the school level and that older teenage, but this can be done for adults with disabilities as well. It does provide a nice a team approach to the decision making. Kind of refer back to what the question that was asked about the child not wanting the parents there. You know, it gives them a team approach. It gives them a way to work it out. But ultimately, ideally, the decision is made by the individual with the disability with the input and support from the team members. It lets the person with the disability choose who he or she wants to be, you know, on her supported decision, his or her supported decision-making team. It may, in a circumstance, depending on circumstances, it may not include the parents. But it may hopefully include, you know, the professionals and people that the person with the disability trusts and wants involved. So what is the decision-making team made of? You know, in addition to the person being supported, it may be just one person. It may be several people, you know, based on the needs and desires of the individual with the disability. It may be as each team member might have a specific area where they provide support. One might be employment, one might be support for living situations, you know, or they may all have just general input, you know, so where the support is provided from. So,
Hey, Brian, this is Dan. A question. So an individual that's going to, say a person turns 18, their decision is to exercise this type of process. I want to do supported decision-making. In that case, that person continues to be their own guardian and then asks this team to come together to assist with the whole process, all these different areas that you're talking about. Is that correct? So there's no court involvement, there's no durable power of attorney, there's no, or there could be maybe in one area, but for the most part, we don't need any of the other pieces then, correct?
Right. In South Dakota, it's more of an informal process. And Carrie, that's correct, isn't it? South Dakota, it's still an informal process.
So there are, I believe, 8 states currently that do have supported decision-making as a legal intervention. In fact, you need to kind of rule out that person wouldn't be successful with only supported decision-making as a legal intervention. In those states, they use what looks like a contract, and then that individual identifies who they want to be on their team. So for example, maybe they had a teacher in grade school or high school that they just really connected with, or a paraprofessional that was really just a great, strong advocate for them. So they might want them to be on their team as they go into adulthood. It could be great Aunt Susie that helps them with their budgeting and finance because she is an accountant. It could be somebody on their medical team, a counselor. Maybe they see somebody for their mental health needs. And so whoever is on that supported decision-making team identified in the contract has a specific role on the team. So it's identified, what areas they'll help make supported decision-making with. And then they kind of operate as an IEP team where they come together. You guys decide as a team, how often should we meet? How often should we get together and do a check-in? Is there somebody helping you with, your living decisions, whether that's an independent apartment or whether that is an apartment with supports, or maybe it's a group home that they live in. And somebody's just going to check in to see how they feel about where they're living and how it's going. Maybe they have a roommate, and so you want to check in once a month or quarterly, or maybe you only want to check in once a year because they're fairly independent. But that is in other states where they have implemented that into the law. That is a legal contract. And so the team members can be switched out. They just all have to sign a new contract stating what they're going to be supporting them with, and then have it notarized. South Dakota, we don't have that yet, but we certainly promote supported decision-making with guardianship, with power of attorney. It's not either or, it's both and in some cases, because we want individuals to feel empowered. So you can have a supported decision-making team in South Dakota, you just would have it be not as a part of your legal contract. Go ahead, Brian.
And let's see. So like I got on the next slide here, kind of to Dan's question a little bit too, like Carrie and I said, South Dakota doesn't formally recognize it right now. However, South Dakota does recognize power of attorney agreements, and power of attorney agreements can be a tool that can be used for the supported decision making. So, I'm going to kind of finish up here with just a story of an individual who went through a lot of this, and we've kind of talked about here today already. Her name was Margaret Jean, or Jenny Hatch. In 2012, Jenny Hatch is a 28-year-old woman with Down syndrome and an IQ of approximately 50. She had been living independently. She'd been working at a job. She was employed. However, after being immobilized following an accident between her bicycle and a motor vehicle that it required surgery, she was not as functional as she was prior to that. She had revoked her parents' power of attorney over her, for they wanted her placed in a group home. In August of 2012, her parents filed a petition seeking to place her in full guardianship, which included the authority to decide where she would live and whether to give or withhold medical treatment. So there's that full guardianship aspect of it. So shortly thereafter, a hearing was held, and Jenny was put in a temporary guardianship, which took away her right to make decisions about her life. As a result, she was placed in a group home, and when she was there, they took away her cell phone, they took away her laptop, and they would not let her see her friends. Attorney Jonathan Martinez entered the case in February of 2013. After a year of litigation in August of 2013, and 6 days of trial involved, Jenny Hatch won the right to make decisions for herself. And this was done using supported decision-making to direct her life to the maximum of her abilities, to choose where to live, what to do, who to see. The court recognized the requirement to give deference to Jenny's preferences. Her case was the first time in the United States that a court recognized supported decision-making, which was previously had been introduced in Canada. So, and now, like Carrie said, there's 8 states that recognize supported decision-making formally. So, so here's a situation where a young woman was doing well and was doing well on her own, and then something happened, and she had someone was granted guardianship over her, and then she didn't want that, worked against that, and eventually through the courts had it dissolved, the guardianship dissolved, and was supported decision making was put in place for her to direct her life. So showing the success and the options that there are to guardianship. So so as a result, this presentation I'm hoping is just kind of showing what guardianship is, conservatorship, but it's also kind of my goal here to outline that there are alternatives to it. You don't have to go straight to guardianship as soon as the child turns 18 years old. So I'm going to just quick bop through a couple of credits and get to my final slide here, and I will thank you for your time. I am going to now thank you for your time. I'm going to not share my screen anymore. I'm going to turn it over to Carrie and let her give some insight on some tools that she has or things that can be used for coming to these decisions. So Carrie, it's all yours.
All right, feel free to interrupt me anytime, Brian.
Okay, I kind of owe you.
So what's really cool about the Jenny Hatch story is, I read through a lot of the testimony and the arguments made by both sides of the attorneys. And some of the things that they pointed out about why she could not be her own guardian were that she, made some poor choices. So she gossiped on Facebook, and she got in a car with a stranger, and obviously that bicycle accident was pretty significant, so they felt like she couldn't navigate her community anymore because she got hit by a car. Well, have any of us ever made poor decisions such as maybe gossiped on Facebook or got in a car with a stranger if you were getting a ride to a party in college and couldn't drive, so you just hopped in somebody else's car that you really didn't know? So a lot of us make poor decisions, but that doesn't necessarily mean that we need to have somebody substitute our decision making. It means that we learn from them, and typically we learn from those decisions, and not to do it is by having some type of pain associated with it. Do you think Jenny probably crosses the street now very cautiously and looks both ways after getting hit by a car? Most likely. Any of us drink too much beer? Possibly. So what we learn from those is you have a hangover the next day, or you have some type of consequence, natural consequences to our poor decisions. And so what a judge did in that case was say, has she learned from these? Has she learned? Has she grown? Has she developed new skills based on some of these mistakes? And the evidence supported that, yeah, she had. So he actually ordered a limited guardianship for 1 year. After 1 year, she could become her own guardian, but there was some skills that she needed to develop within that year. And so it was time sensitive. And then Jenny got to choose who that guardian would be. And it happened to be, she worked at a thrift store, and the owner of the thrift store became great friends of hers. And so the judge ordered limited guardianship to the owners of the thrift shop. And so after that, now Jenny's been her own guardian. And again, IQ of 50, right? Like unheard of. So what we learned from that situation is that there's lots of people with disabilities that just need increased supports. They need increased supported decision-making. Yes, parents are one natural support, but what other community members out in the community are also considered those supports? If they've been going to church for a long time in their community, if they've had classmates in school, what are we doing to foster those relationships outside of high school so that some of those supports that they have throughout their school age life continue on into adulthood? And quite honestly, like those could be the supported decision-making team members as well. I'm going to share my screen. Can you guys see my screen? Nope. All right, let's try this.
Yeah.
How about now?
Nope.
Still no?
Still no.
Okay. Well, I might need, oh, that's because host disabled participant screen sharing. I don't have your permission, Cindy.
I gave it to you earlier. Oh, you know what, Carrie, I never did give it to you because I did it earlier. Okay.
That's all right.
Sorry
So real
about
quick,
that.
I'll just introduce, a little bit about myself. I do work for the Division of Developmental Disabilities, formerly worked at Disability Rights. So Brian and I know each other really well. And we all share the same passion, and that's people with disabilities. I am a parent of a child with a disability. I actually was a foster parent, and with God's sense of humor, blessed us with a set of twins, one with Down syndrome and one without. And so we have raised the twins they'll be 14 in March, which is quite insane that they're going to be 14. But Kashmir and Kashmir, even though they're twins and they're 1 minute apart, very much have different abilities. Kashmir's IQ is about 43. Kashmir's is much higher than that. And so as I've raised the girls, I've learned that I don't necessarily need to lower my expectations out of Kashmir, my daughter with Down syndrome. I need to elevate her supports. And I learned that the hard way. Kashmir said to me one time when we were doing Saturday chores and Nay was over playing on her iPad, Kashmir said, how come Nay doesn't have to do chores? Yeah, that's a really good question. How come Nay doesn't have to do chores? So what I needed to do is give Kashmir the right chores that would meet her skill level. And so now everybody does chores on Saturday mornings, but Nay might need a visual support to remember what her chores are. She might need, training more than one time, where Kashmir, if I teach her how to mop the floors, I can show Kashmir one time how to mop the floor and she knows how to mop the floor. With Kashmir, I might have to teach her 7 or 8 times before she can really get that skill down. So I learned real quick not to change the expectation, but really to elevate those supports. So as I move into my own decision-making at age 18 of whether or not to obtain guardianship, I have a lot of things to consider. I always want to use supported decision-making as the main tool, but we might need to have some legal interventions, and that's okay. But I just want to be able to make informed decisions. So can you guys see that? Is that good?
Maybe you've got it in presentation mode, I think.
Yeah, if you go up to display settings
Yep.
and then click on that and then, yeah, hit swap. There you go. Yep.
Good? Okay. So how do we transition into adulthood? How do we even know which decision is our best option? It's really quite stressful for families. I'll be honest with you. When we get to that age, we're going to struggle with this decision because we don't want to make the wrong decision. And maybe we make the wrong decision, and how do we undo it if we do? So I'll just real quick tell you a little bit about what our state is doing. Our state has become part of the National Community Practice for Supporting Families. And what that means is that there is a whole group of people all throughout the United States that are really struggling with the same decisions that we have, and really want to feel supported as family members. We want to make sure that we are empowering our family member with an intellectual or developmental disability, but not necessarily taking away from their life experience. And so the Supported Families Community of Practice really, their core belief is all people and their families have the right to live, love, work, play, and pursue their life aspirations in their community. In their community is a key to that. A lot of times we think of when they become adults, they need to live in some type of supported living environment. And consequently in South Dakota, that means that we have to look at what facilities have availability, right? So I live in Sioux Falls. We have lots of facilities in Sioux Falls, but not a lot of openings because we're a highly populated area. So if I were to go and look for residential services, I most likely would have to send Kashmir to a different part of the state. And so now I'm taking her away from people that she went to school with, people she went to church with, myself, her siblings, her cousins, because there's no services or supports within my community that would be able to serve her residentially. And so that's just an unintentional consequence to what our services and supports look like in South Dakota. And so when we think about having the right to live, love, work, and play, what does that look like? What does that mean? Well, we all want the same things. And why would that expectation change for somebody with a disability? So we've implemented some tools that we use to help families really navigate what they even have available in their community. So if they want to stay in their own communities, they need supports, how do we navigate some of the things that we already have access to? Eligibility specific certainly would be either like the Family Support 360 waiver or the Choices waiver, voc rehab services, independent living services. So those are all eligibility specific. But then there's that community. How am I known in my community? What relationships can I leverage to meet those support needs? And then what technology? Right now, we use a ton of technology in our family. We use Amazon Alexa for prompting. We use Alexa for reminders for time to take a shower, time for bed. Alexa, what's the weather today? How should I dress? So really working on gaining those independent living skills with technology. There's also technology in our home because Kashmir had a couple of instances where she eloped. And so she left the house and we had to call law enforcement to help us find her. So now we have alarms on our doors that just alert us when a door is open. So I know that somebody might be going out or coming in. Can I tell you that's also quite handy when you have college-age students home for Christmas break and you find out real quick what time they come home, and then we talk about life choices. So when we think about the all, we think about the all, right? So it's not just benefiting Kashmir. We use Alexa for a lot of different things, shopping lists, but then we also use the door chimes for a lot of different reasons, not just for Kashmir's needs. So what does any of that have to do with decision making, whether or not I should do guardianship? Well, Supporting Families Community of Practice has developed some tools to help us. One of those tools, and we'll send it out to you as well, is this tool for exploring decision making. It's very similar to the stoplight tool for those of you who have used the stoplight tool. There's 3 boxes. So the blue box is I can decide with no extra support. The purple box is I do need some supports with my decision making. And then the green box is I need someone to make all those decisions for me. And so as you're working with your students, you certainly can work through this and just kind of ask the questions either with the family or with the family and the individual, which would be ideal because we want the individual to kind of say, gosh, yeah, I want to work on that. No, I can't do that yet, but I want to work on it, which also can help you create some transition goals. And so you work through this tool. It goes over all the different life domains, and a life domain is like daily life and employment, healthy living, advocacy, are they registered to vote? There's all kinds of different life domains throughout the lifespan. And so we try to pick questions that really are helping them make decisions. And so when you get done using this tool with the family and the individual, if you find you have a lot of check marks in the green boxes, full guardianship might be the alternative that you need to use, or a limited guardianship. So I need help making decisions over just the areas that have the check marks in them. If there's a purple box filled out, mostly check marks in there, hardly any green, then power of attorney might get you what you need. You might just need power of attorney over making financial decisions or medical stuff. Again, I have adult children. My husband and I, between the 2 of us, have 9 kids. So we have a large sample of children's supports. And so when we look at what areas, you know, I'm going to be honest with you. I didn't help my older kids open a checking account. Their dad just did it for them. So if they were to have to walk into a bank today and open a checking account, even though they're 23, 21, and 20, I don't know if they would know the process to opening a checking account. They might have a good idea of what they need to ask, but they've never physically done it for themselves. And so, you know, as we're looking at this tool, maybe they need support. So some of my children without disabilities need support in making some decisions in the purple boxes. That just means that I have more work to do as a parent or as an educator to really work on some of those skills. And then if you've got mostly check marks in that blue box, supported decision making is just probably your best bet, or you can do that with power of attorney as well. So it's just a nice tool. Off to the right side of the screen, you can see the safety and security supported decision making star. So these are some ideas of things that you would want to consider if you really do have concerns about safety and security, exploitation, being taken advantage of. They're just a little bit naive and they're not, you know, ready to be independent in these areas. Well, here's some ideas of each of the sections of the STAR that you can consider and just kind of ask that question or build up those supports in those areas. All right, that was a lot, huh? This is my contact information. If you have any questions, feel free to email me, call me. I certainly am happy to visit with any of you. And I know Brian as well shared his information. You'll have each of these PowerPoints, but we wanted to give you guys a few minutes at the end here to ask any questions you might have, or just share any thoughts you might have. I'm gonna stop sharing my screen so I can see your faces.
I have a question. We have a student out here in Rapid City who is currently employed by the hospital. One of those lower IQ kids has some hearing issues, especially on the phone. The hospital will not contact the parent and talk to the parent. Even if he hands them the phone, it sounded like that they would not do that. Is there a waiver or something? How does that work with, they said unless he's their legal guardian, unless his parents are their legal guardian, they can't talk to him, to them, I mean.
So do you want to hear something crazy? Here in Sioux Falls, at one of our providers that my kids receive services through, age 13, I got kicked off of their MyChart. Age 13, with or without a disability. And so all I had to do is sign a proxy form. They had to sign it. So even Cashman had to sign a proxy form saying that they could communicate with me and I could have access to their medical information.
But it wasn't, they're an employee of the hospital. The hospital's hired them. This is a Project Search student that got hired. And now they're having issues because, like I said, the hospital will not talk to the parent because there's no guardianship there.
Yeah, but that's an employment thing. That's a HIPAA thing with an employer talking to a guardian or a non-guardian, just a family member. I certainly wouldn't want my boss sharing information about me to my family members. So, really the issue is, what are the questions the family has or wants to know, and is there a way to get that information?
It's the other way around. Okay, so for example, he has not shown up for work. So they want to call and find out why is he not coming? Is he sick? Is he ill? Is there something going on? Well, he can't hear anything on the phone, but they won't talk to the parent.
Yeah, I don't think that's a guardianship issue. That's an interpersonal relationship issue.
Sounds more like an employment issue.
Yeah.
You know, ma'am, if Lily, if they do have questions about something like that, they can contact my office, Disability Rights South Dakota, and that might be something we could provide them some guidance on.
That would be awesome, because we have a number of students that are those lower functioning, you know, lower IQs that just need a parent every now and then to say, hey, you know, I didn't know he wasn't doing that, or, you know, whatever. So I will go ahead and get them their name and number. Thank you.
The nice thing about disability rights is that they are always available to provide information and referrals. So even if it's not a representation issue, but it's just a question, or where do I find this? Disability rights is super knowledgeable and can provide some guidance. And they also have an attorney that sits on the intake team. So you're kind of getting some free legal advice too, if it's legally related.
Yeah, when you provide them with the information, rather than providing them with my name, because I'll just redirect them, ask them to just request to do an intake, and they will, then that will get them instantly right on the right track, rather than coming to me and then I redirect them.
Okay, thank you.
Good question. What else do you guys have? All right, Dan, I think you had some follow-up items you wanted to talk through if nobody else has any questions.
Yeah, thank you, Brian and Carrie. Very good. Lots of good information. We will have the recording of this posted on our website, www.tslp.org. And Cindy put that in the chat at the beginning, so that website is up. That'll be available next week, hopefully. Hopefully within 10 days, we'll say. Thanks, Cindy. Cindy just posted it again, so it's up. Oh, just a few things to kind of go over with you guys. Number one, and that's not on this list here, is that we will have a newsletter. Jenny, I think, is about done with it now. And anyway, the TSLP staff put together a newsletter, and we're going to start trying to put something out every month, just our events, what's coming up, what type of activities we're doing, and maybe a story or two, or a compliance, an Indicator 13 compliance tip for the month. We're going to be doing Ylf delegate interviews here through probably the middle of March. We have a lot of students that applied, and if you know of a student that applied for Ylf and they haven't been contacted in the next week, please let us know. Let your liaison know, or maybe even the VR counselor if you don't know how to get a hold of us. But let somebody know that the student hadn't been contacted, so we make sure we're including everyone. The Let's Talk About Work event, we weren't able to do them this fall because of the COVID-19 issue that everyone gets to deal with. And so what we did was we put together a recording of like 4 different groups. And so we've got it all recorded. I think we're done with it now, and we'll get that posted on the website. It actually follows a PowerPoint and has activities for the students and those kind of things. So it's kind of good. It's something that you can watch periodically with your students. Some of the activities are 20 minutes, some might take 30 minutes, but you can kind of pick and choose how you go through the whole process. We just want to make it available, and you can use it as you see fit. We're also doing some Ylf Gatherings, which are monthly. We have meetings with students that have attended Ylf in the past, and so they can get on and kind of catch up with each other and see what's going on, see what other students are doing, or now adults. Well, many of them are adults and they're working different places, so it's kind of a good event for that group. And then we will have another teacher roundup coming up in February. So February 24th, be the last Wednesday of the month from 3 to 4 Central Time. So we'll send information out on that in a couple of weeks. I'll have a topic for you and probably someone to share some more useful information. Cindy, do you have anything else?
I just have one thing. Quite a few of us on this call, including Brian and Carrie, are working on a guardianship roundtable committee where entities from different agencies, mainly Division of Developmental Disabilities, are looking at putting together a TA document. Maybe it's a one-page thing that educators can have that explains this process, kind of, that you could hand to parents. Also, now we're partnering with Parent Connection because they have an interest in developing a little bit more developed handbook to alternatives guardianship. So hopefully within the next 3 to 4 months, something like that will be available for all of you too, because it's a hard process, these decision makings, plus it's an emotional decision making for parents and everybody involved. So man, Carrie and Brian, you guys did perfect timing. Everything went really well. Thank you very much.
You're welcome.